All right, so that actually happened before lunch. That was what I was referencing in terms of the defense attorney speaking to the judge, letting her know, I think in so many words, that she wanted to testify, but I think he was saying to the judge, I really don't want her to. So there was this plea there. Let me bring in our guest to talk a little bit about what all happened this afternoon out there in Summit, Ohio. Joining me now to discuss is criminal defense attorney Jeffrey Wolf. Jeffrey, thank you so much for joining me this afternoon.
Thanks for having me on.
All right. So what I was talking about earlier was that little scene there between the defense attorney and the judge. And it almost felt like the defense attorney was pleading with the judge to give him more time to try to convince his attorney. It was clear to me in what he was saying that she was saying she wanted to testify, but that's not what he wanted.
Right. And you're 100% correct on that. When you have a plan for your client to testify and they're about to get on the stand, you stand up and say, my client is going to testify. Going to testify, not wishes to testify, not might testify or has been wishy-washy about it. Once you start saying things along the lines of, my client has changed their mind, my client wishes to take the stand, that is a signal to the judge that you need a stronger Curtis advisement, that you need your client to get that information from the judge again to be able to possibly have a second guess here and decide not to testify. And any lawyer that has been ready, prepped, and excited for their client to take the stand in a case stands up confidently and calls their client to the stand. If you are not ready for it, if it is a change of mind, if it is something that you think is a bad idea, you use the couching language that he used. And it is clear that he is going through the advisement himself again, hoping that it'll hit his client. He is clear that he is laying out the advisement for the judge to go over again, hoping that it'll sink into his client's mind. It is plain as day that he wants nothing to do with this testimony.
Yeah, and I thought the judge handled it great, just like she's pretty much handled everything in that courtroom, allowing him not only that opportunity, but then even after lunch, allowing him another opportunity to talk to his client so they could continue to confer and come to the right decision. So let me ask you, was it the right decision?
I think it probably was. I think when your client testifies, and I'm not one of those lawyers that says don't put your client on the stand. I know that some people go by that. I don't go by that. I think your client takes the stand if they need to take the stand. If the jury needs a why, how did we end up here? Why is this person being falsely accused? Then you put them on the stand and you let them explain that why and you let them get their story out there. In this case, the why is as clear as day. She has a jilted ex-husband sitting in prison. She gets remarried. He reopens all of these wounds and brings this all back to the forefront. That is the defense theory of the case. They don't need her to testify to say that. She could do only damage here. There was nothing to add.
Yeah, I thought the defense did a masterful job in sort of crafting their defense. With each witness that had damning evidence, they made a point of making it seem like there was some ulterior motive, the idea being that they didn't like Erica, they wanted to get back at Erica, but also wanted to help out Chad. I think that became very clear throughout the case. And again, without the direct physical evidence, and you have all these sort of people connected together, I thought the defense has a pretty good chance here.
I agree with you. And that's why I was saying that they really did a good job of putting the why out there without her needing to testify. They were able to hit Chad with the information about when he found out about the divorce and when he found out she was sleeping with his best friend and now pregnant and getting married to him. They were able to hit the mom with the intoxication during the conversation, everything that they're hoping could come out of Chad cooperating with reduction of sentence or, something with the kids and visitation and things like that. They were able to, like you said, masterfully weave in the why throughout their case. It was their theme. Right? This jilted ex-husband who wants to get a benefit from the ex-wife that he's angry at. They laid it out clear. They did it with every single witness, like you said. They hit that point. They were in and out of cross-examination with those points when they needed them, and they got the why, and that's what they needed. Why would he come forward? The time that went by in and of itself is a big problem for the prosecution, but the defense being able to get the why now in front of the jury was masterful.
Yeah, and ultimately the defense didn't hit much on the time. There were many who thought that that was a place where they could really gain some traction, but they didn't seem to hit on the time all that much. One of the reasons why I thought she shouldn't testify was her personality. Now, we didn't get to hear from her at all, but just the way she was portrayed by so many witnesses, I thought maybe the type of personality she had wouldn't go over well in a courtroom, certainly on cross-examination. Are there times where you take that into account, the personality of the person you're dealing with?
You just described the most sensitive conversation any defense attorney ever has with their client, which is when you have that conversation where you basically tell them that they're not going to make a good witness. And whether they don't have the temperament for it, or whether they don't have the personality for it, or if they can come off a certain way, whether it's aloof or angry, whichever negative connotation their personality has for them, that's the hardest conversation to have with a client, to say, you blow up at the drop of a dime when we're talking about this case. What makes me think that the prosecutor who's going to be trying to get you to blow up isn't going to get you to blow up when you blow up at me, right?
Right.
And that's the hardest conversation you can have with your client, because they always think that they're their best witness, that they know what happened, and sometimes the presentation plays into it. And when we're talking about a woman who is, accused of defecating on a grave, sleeping with her husband's best friend, the posts on social media, I mean, it's not good. And I could understand where her lawyer is coming from, especially as she's, furiously taking notes throughout the trial. And all of a sudden, here's all the grievances that I have with all these witnesses. I've got them all out in paper. Let's go. Prosecutor.
Yeah, that was my issue, Jeffrey, because she initially didn't want to testify, then suddenly wanted to, because probably she wanted to get back at some of the things that she was hearing, and that is the last person that you want to put on the stand. All right, Jeffrey, stand by. We got a lot more to discuss. We'll be coming back right after this break. Now, when we do come back, we'll hear testimony from the lead detective, and that might have influenced today's drama over whether Erica Stefanko should testify. And we'll go in more in depth into that when we come back, so stay with us. All right, joining me now to discuss is criminal defense attorney Jeffrey Wolf. Now, Jeffrey, let's talk about Michael Hitchings and what he brought first to the prosecution's case. I mean, it was clear he was the lead detective. You got to bring him in. He gives you all those sorts of details. But one of the issues with his testimony is that really there was no physical evidence. And I thought the prosecution did a fairly good job of getting him to say, look, she was probably involved, and he couldn't say she was because he didn't know, but somebody had to have picked him up. And then he also dealt with what I call the CSI effect. Juries like to see sort of some physical evidence connecting, but he said, look, this is not the kind of case where we can have physical evidence. You just have to sort of circumstantially piece things together. So I think in that sense, he was helpful, but also hurtful.
I agree with you. The CSI effect, as you call it, is 100% real. Juries want to see something, right? Something to tie it to them because it's what they expect, because it's what they see on TV, which, as we know, is not always what you actually get. And at the end of the day, I think the things that were really interesting about his testimony from the prosecution side was he just seemed ill-prepared, in my opinion. He couldn't remember dates of social media posts that were a linchpin of their case. He was speculating quite a bit. I don't know where the objections were of what that had to have happened in this case, which he obviously doesn't know, because when he's investigating it back then, he has no idea of who to tie it to or how to tie it to them. And so the CSI effect of trying to say, we don't have the physical evidence, this isn't the kind of case where we can find the physical evidence. Well, that's our job, is to start making up all the things that they could have done, right? Did you sweep, for fingerprints here? Did you swipe for them there? Did you look for hair fibers there? Did you look for hair fibers here? Did you look under the fingernails? Did you do this? Did you do that? And he didn't do them, and it just starts mounting up on them, and there couldn't have been any physical evidence thing doesn't play with most jurors, because they are expecting to see it.
Yeah, and you know what? You bring up that issue, and I agree 100% with you. Not only was he ill-prepared, but I got issues with the overall investigation. You're in this case, a woman made the call. He even says it's likely she picked him up, but yet they don't continue to pursue her. It takes 8 years and a whole lot of other machinations to get her into court. I mean, that bothered me.
Well, the case came to them, right? They didn't go to the case. They didn't do the investigation that they should have done. That's what you're saying, and you're right. But here's what we don't know. At that time, did they try to question her and she asserted her Fifth Amendment right? Because if she did, they're not going to be able to bring that up in the trial and tell that to the jury, because she has a Fifth Amendment right to silence, and it's not to be presented to the jury as something prejudicial. So we don't know that for sure. But what we do know is that it took them a lot of sitting on their hands. They didn't just charge and say, we've got this circumstantial evidence, because if circumstantial evidence was enough for them in this case, they would have charged her way back when. They wouldn't have waited until Chad came forward and his mom came forward. And so you're correct. The investigation is sloppy. It was, stop, start. And like I said, the case came to them. They didn't go to the case. And I think that when you see him testify and he can't remember the dates of what is arguably the most important thing on his plate this week, it tells you everything you need to know.
Yeah, and you know what else he couldn't remember, Jeffrey? He couldn't remember that O.J. was innocent. So
I saw that.
So that to me just put it right out the window.
Yeah, that was junk. I saw that interaction earlier when I was watching, and that is garbage.
Exactly. And so now on cross-examination, the defense did what they've been doing all along. And this goes back to why I'm very sure he didn't want his client to testify, because throughout the case, he's really kept all the focus on Chad. And that's exactly what he did on cross-examination. He must have said Chad's name 1,000 times throughout this trial, because he wants that jury to focus just on Chad, not on his client.
Right. Well, because Chad killed this woman. Right? If everything that the prosecution is saying is true about Erica, she didn't kill this woman. And everything that they're presenting is that Chad is this abusive husband to this woman and then ultimately ends up killing her over a custody dispute. Chad's the bad guy. Why do we think that Chad didn't do anything to Erica? Why do we think even if Erica did this, that she wasn't coerced into it by Chad? Chad is the focus here, because Chad is the one who has pled guilty to murdering this woman and is now coming in with his mommy to try and blame somebody else and reduce his sentence. That's why the focus is on Chad, because that's who this case is really about. 12 years later, they're trying to tie up a loose end in their investigation. This case is about Chad. It's not about Erica. If I'm her lawyer, I don't want to talk about Erica at all. Who's the murderer? Chad. They're charging her with murder for a phone call that they think she made. That's it.
Yeah, and that's exactly the conversation he probably had with her, because putting her on the stand then shifts everything away from Chad and then puts the focus on her. And not only, I always believe this, it shifts the burden onto her.
Mm-hmm. I do agree with that. I think that when you're, like I was saying before, when you put your client on the stand, you're usually trying to get to the why. And if you're trying to get to the why, that is the defense trying to prove something, which is the defense taking on the burden from the prosecution. And so once somebody's up on the stand, everything that they're doing is being scrutinized, and we're no longer scrutinizing the prosecution's case and their witnesses. We're now scrutinizing the defense and their case. And that is burden shifting on yourself when you do it. And sometimes you have to, because you need to get the why out there. Innocent until proven guilty sounds great, until you start talking to some juries after some tough trials and you start realizing that they do need to hear your client give them the why. But in this case, they didn't need to. This case is about Chad.
Yeah. And finally, let me get from you what you think tonight is like, or tell our jurors what tonight is like for the defense attorney. I mean, actually, the entire weekend is probably just going to be focused on his closing and the amount of work and sort of the worry and all the things that are going on in his mind.
So he's going to take this afternoon. He's going to take this afternoon and he's going to breathe. He's been sitting in a COVID courtroom hoping he doesn't get sick for a week. And he's going to take this afternoon and he's going to clear his mind. And then he's going to come back and he's going to review his notes. He's going to review any notes that he gets from his office. Presumably they're watching the trial and taking notes and helping him out and giving his assistance. And then he's going to put it all together. He's going to go back to the framework of the closing that he probably walked into this trial with. And he's going to decide what changes need to be made. And from there, it's going to be practice, repeat, practice, repeat. If he does this closing argument like any great defense attorney would do, he's not going to be reading off of his notes. He's not going to be looking at a bullet list. He's going to have it all up here. And the way that he's going to get it all up there, he's going to spend the entire weekend, rinse, repeat, change, rinse, repeat, change, final version, ready to go.
There you go. All right, we're at the top of the hour, so we're going to take a quick break. And when we come back, we're going to take a look back at the courthouse in Ohio and get you ready for what's coming up in this trial. Stay with us. All right, that was the direct examination of Mike Stefanko, the only witness called by the defense. All right, joining me now to discuss is criminal defense attorney Jeffrey Wolf and family law attorney Jennifer Brandt. Again, thanks to you both for joining me this afternoon. And let me start with you, Jeffrey, and say how you thought this particular witness did and what he added to the defense's case. He was their only witness.
I don't know that he added much of anything, quite frankly. I think they were trying to humanize her a little bit because a lot of the witnesses had been tearing her so far down and throwing so many things against the wall about how horrible she is that I think that that was the goal, was to try and humanize her a little bit and dehumanize Chad a little bit as well by bringing in, this is his close friends, this is somebody who knows him really well. And the problem is it plays both ways because this is his best friend who's now married to his ex-wife and was sleeping with her when she was still married to him. So honestly, I don't know. I don't really know what the purpose of calling him was. Maybe it was an agreement between Erica and her lawyer. Maybe they decided that this is what she wanted. She wanted to be able to see him face to face in there in the courtroom because those, love letters that you guys were talking about earlier, they were there. You could see them clear as day. And I didn't know what the point of it was. I don't know how in the world, if he's going to watch court TV and see what happens, you let him talk about it on the jail phone the night before so the prosecutor can hear that. Just insane. And at some point, we got to take a minute and talk about the ridiculous face masks in this trial. I just can't get over them this whole time we've been watching this.
Yeah, I want to get into this COVID issue because it really permeates every trial we've done since we've sort of got up and running again across the country with trials. And Jennifer, let me go to you and ask you if you thought that he was an effective witness. I thought he was really just a proxy. At the time, I think the defense attorney didn't think that his Erica was going to testify, and he thought this was the best way of maybe getting some information about her in front of this jury that was positive.
Well, I agree with what Jeffrey said for the fact that I think it was important that he was the best friend of Chad, and then to understand why Chad would be so upset with Erica for turning around and marrying his best friend. So I think from that point of view, from a strategic point of view, of showing the relationship there and why Chad would then turn in his former wife, I think that's what made it most effective. Not so much of what he said, but the fact that they had this great relationship. He and Chad had been friends forever. Chad called on him when this event happened. And, and then he turns around and marries Chad's wife, and Chad gets pretty angry at that. So I think for that reason, he's an important witness.
Now, Jennifer, this is the first opportunity I've had to speak with you, so I want to ask you the two questions that I ask everyone when I first encounter them on the show. Number one, where you stand on this trial? Do you think the prosecution has met their burden?
I'm not so sure about with Erica because I think, clearly everyone's looking at Chad and the wrongdoing that, of what he did, and now she's kind of being brought into this. I don't really think so. I don't think that they've met their burden.
All right. And secondly, should she have testified?
No, I don't think it would have helped her to testify at all. I think it's better that she's silent. I think, I don't know how sophisticated she is. I don't know really what she would say. And testifying is only a chance to fumble. So it's almost better. Let the facts speak for themselves. Let the trial go on. Let the prosecution meet their burden or not. Without her getting involved at all.
Absolutely. I agree with you there. Jeffrey, now, as far as Mike Stefanko, you talked about the fact that he had watched court TV, and I thought the defense made a lot of hay of that, and I thought it was extremely effective.
Well, I think it was effective and also a very good ad for you guys, which is great. But ultimately, at the end of the day, the fact that he was doing it is bad, because he absolutely should have been advised that he's not supposed to do anything like that. And then the fact that they were dumb enough to get on the phone and talk about it, which is clearly what happened here, right? This isn't something where they're guessing, oh, that sounds a lot like what somebody said yesterday. She's being very clear that there is a phone conversation out there where he mentions this. And at the end of the day, the reason she's treading so lightly is because that conversation is hearsay unless he slips up and denies something that's in there, and then she can impeach him with it. And that's what she was trying to get him to do. And luckily for them, he didn't do it, because I think they play that phone conversation and God knows what else is on there, and game over, I think, probably. So he got real lucky, I think.
Yeah, and Jennifer, sometimes, I don't know, you tell me as a defense attorney, do you feel the pressure to call someone? I mean, you almost don't want to rest without at least putting on some type of case.
It's true, but I think here there's not enough evidence. So I think it's sometimes better not to call anybody. 'Cause as I said, it could just cause more trouble than good sometimes.
All right, you guys, I want you to stand by. We have a lot more to discuss. Coming up next, we're going to take a look back at the testimony from the former husband of Erica Stefanko. Yes, that man, Chad Cobb. Stay with me. I tell you, that never gets old. Joining me now to discuss is criminal defense attorney Jeffrey Wolf and family law attorney Jennifer Brandt. And let me start with you, Jeffrey. Chad Cobb was he was a wild card. And initially, I thought that maybe he just wasn't well prepared, but I just think he had his own agenda. As an attorney, how do you deal with a guy who really seems to have his own agenda?
Well, the one thing you don't do is basically show that you're not in control by asking the judge to tell him to answer the question. You can give him an opportunity to answer your questions, and if he's going to refuse to answer your questions, you're going to point out to him how simple the question is, and then you're going to give an eye to the jury that he won't answer your question. Asking the judge to instruct a witness to answer your question in front of a jury shows that you are not in control. That is not your witness. It is clear that Chad had his own agenda. What he's trying to do is set up his own new appeal. He's trying to make it like there's new evidence. I didn't actually do this. If he says that in Erica's trial himself, suddenly that's new evidence. It's clear what he's doing. He's trying to get her convicted to get back at her, and he's trying to cast doubt as to whether his plea was voluntary and whether somebody else did it, and he now has that information, and they should bring him a deal and get him out. I mean, it's clear as day, but you can't let a witness take over like that. You keep asking the question, you point out that it was simple. If they won't answer the simple question, you say, maybe I worded it incorrectly, and you reword it even simpler. And if they won't answer that, you give the jury a look and you move on. You got your answer.
Yeah, Jennifer, it seemed to me like Chad thought he was smarter than everybody else and was going to go about this during this trial and get this information in and, like Jeffrey said, get possibly a new trial out of it. But at the end of the day, I think he probably hurt the prosecution's case. I don't know if it's irreparable, but I think he did serious damage.
I totally agree with you. I don't think he was helpful at all. I mean, some of the things he said just didn't make any sense. And if Erica was so guilty in all of this, as he claims, then why didn't he bring her up initially? I mean, if he was going to try to save himself and he didn't do this, then why didn't he bring this up when he pled guilty back in, 2013? It's been a long time. So all of a sudden now he's having a different recollection of the events, I believe. And I think that was pretty clear from what we just heard.
Yeah, Jeffrey, he's going to have to address this in closings, don't you think?
Absolutely. I think both sides will have to address it in closing. I think the prosecution's going to have to try and explain it away, and I don't think they're going to be able to do it, quite frankly. And I think the defense is going to have to hit it hard. This case, like I said before, is about Chad, and they need to make it about Chad. This guy is a liar. This is somebody trying to put blame anywhere but himself. This is somebody just trying to get out of prison and get back at his ex-wife. They are going to hammer this, and they should.
Jennifer, as I look at cases sometimes, I think of it like sort of a Jenga, where as a defense attorney, if you can pick away little pieces, eventually that case might fall. Now, Chad is such a big piece of their case. I don't know how credible anyone can consider him at this point. If he's not credible, and if he sort of plays into this narrative that everyone's trying to help him out with coming to court and trying to point the finger at Erica, does the entire prosecution's case fall under the weight?
I think it does, because I don't think that there was enough evidence here really to implicate her. Although you do have the fact that she had obviously a poor relationship with Ashley. I mean, that we know about, and that she was upset about the change in custody. Even though this wasn't her own child, this was Chad's child. I think because she was his wife, and this happens many times, obviously she feels a strong allegiance to him and really didn't like Ashley and said some really terrible things about her. But still, is that enough to implicate her in this crime? I don't think there's enough evidence here.
Jeffrey, he's the only one that actually places her at the scene. Because the testimony of GC was she heard the phone call, but really couldn't place the scene. She was in and out of sleep. The mom has the phone call where she seems to make admissions. We'll get into that in a little bit. So really, let's say we get rid of Chad. Do you think the jury has enough there with just the phone call and the phone call admission and GC, her testimony? Is that enough to convict?
I don't think so. To address GC first, there was a portion of GC's testimony that I think, like you talk about with the Jenga, I think it's pulling out some of those bottom blocks where she remembers all of these details as it pertains to Erica, but she doesn't remember who her mom is. And that's extremely troubling. Where did she get all the information about Erica if she can't remember who her mom even is and what she looked like? And you put on top of that she also is making it clear that she loves her dad and she'd like him to come home. So you can see where GC is invested here. That her father is convicted of murdering her mother and she wants him home, but thinks that Erica needs to be punished. That's extremely strange. About GC's testimony was extremely strange. And then the mom, I think that the big issue with the mom was the issue of Erica being intoxicated and the mom feeding her liquor is a huge issue that I would make a huge thing of if I were on this case. But I think the fact that she had that recording sitting in a safe for so many years and then finally decides to bring it forward when Chad decides that it's time for all of this to come to light, a little too convenient.
Yeah, it's rough. Well, Jeffrey Wolf, I want to thank you so much for being with me the last couple of hours. Enjoyed your insights. We're going to let you go. Jennifer Brandt, you'll be sticking around for the next hour. We have lots more testimony in the case to take a look at. So stay with us here on Court TV.